Okay, I think we're going to go ahead and get started. So first of all, we wanted to welcome everyone who's joining us in person and virtually, and a big thank you to Vetter Price for hosting this year, and thank you to you all for being here. And with that, I think we can go ahead and jump in. In just 1 second. Okay, thanks. Okay. Okay, so now we will go ahead and get started. So this is our agenda for today. We're going to start off with a brief overview of NIJC, our organization model, our services, a little bit about our pro bono experience. And then I think this agenda is a little bit out of order. We rearranged recently. So after that, I'm going to hand it off to Vetter Price attorney Josh Dunn to speak a little bit more to the pro bono experience. And then we will go over the basics of asylum law before jumping into some more nitty-gritty elements of asylum. We'll have a 10-minute break after that to get some food, some coffee, and then we'll start talking a little bit more about preparing your case, what to look for when you're getting started with your client, some of the details of actually working with your client throughout the life of your case, and then we'll go over preparing and presenting the facts of the case, and we'll finish out with a Q&A. So our presenters for today, I'll let my colleagues introduce themselves. My name is Lily Henkel. I use she, her pronouns, and I am the pro bono coordinator for the Asylum Project with NIJC.
And I am Jeff Cibola. I use he, him pronouns, and I'm a senior attorney on the Asylum Project.
Good morning, everyone. I'm Olivia Judd. I use she, her pronouns, and I am the managing attorney for the LGBTQ and Asylum pro bono projects.
Okay, and then in addition to us, we have some other contacts up here for you as well. So you can reach out to any of our attorneys on our pro bono asylum team for legal, procedural, and strategy questions. So we have Anisha Gandhi, Olivia, and Jeff, and then Julie Rich. For questions about Afghan cases, you can reach out to our Afghan project coordinator, Eamon Shah. For questions about LGBTQ cases, you can reach out to our LGBT Immigrant Rights Project coordinator, Moises. And for any other questions about other types of asylum cases or general client or procedural questions, you can reach out to me. My email is up there on the screen as well. So a little bit about NIJC. Our organization is pretty unique in that we have a number of different projects that all work together in order to advance immigrant justice. So as you can see on the screen, we have our national and local advocacy and education projects that also work with our federal litigation and legal services projects. Our legal services projects represent and provide services for over 9,000 non-citizens, and then that includes our asylum project in there as well. We also have within that our wonderful network of around 2,000 pro bono attorneys across the country who are working with us. And we have offices in Chicago. We have 2 offices in Indiana, 1 in Goshen and 1 in Indianapolis. We have an office all the way out in San Diego, California, and we have 1 in Washington, D.C. That's where our policy team is housed. So a brief overview of NIJC's pro bono programs. It starts with our clients. An immigrant will contact NIJC because they're in need of representation, and then our staff will conduct a screening, an in-depth screening and assessment of their case. And then if we find it viable, we can choose to accept their case. We sign a retainer with the client, and we provide representation while we look for pro bono placement for that client. So you have the knowledge when you take a case with NIJC that it's already been vetted by our staff. It's a viable case. It's a strong case. It's winnable. And then lastly, a pro bono team will accept the case. They will take it on, and NIJC will remain of counsel, so we continue to have a vested interest in the outcome of the case. We provide attorney support, we provide document review, technical assistance throughout the life of the case. In addition to our asylum project, we have a number of different pro bono opportunities with NIJC. there are opportunities to get involved with special, did the screen just, I think it's, okay. We're back. To get involved with special immigrant juvenile status predicate orders. SIJS is a type of status available to non-immigrant children who have been abused or abandoned by one or both parents. We have a number of different clinic opportunities where we partner with law firms to put on clinics for DACA, naturalization, family petitions for asylees and refugees, and then adjustment applications as well, green card applications for asylees and refugees. Then we have our Asylum project, of course, and there is an opportunity to get involved with a number of different kinds of clients. We work with adults, we work with family units, we work with kids, and we work with detained immigrants as well in our Asylum project. We also have opportunities to work with immigrants who've experienced violence, so VAWA and U-Visa relief. VAWA is the Violence Against Women Act. U-Visa is a type of relief available to immigrants who've experienced certain qualifying crimes. And then last, but definitely not least, we have our LGBTQ Immigrant Rights Project, which is a population-based project, works with LGBTQ and HIV positive immigrants who might be pursuing a number of different forms of relief, including asylum. It really can't be understated the importance of pro bono attorneys for immigrants. Non-citizens in the United States do not have the right to counsel. So we have a graph here that's really tough to see because there's so much on it, but it's showing the adjudication statistics for 2022 for asylum grant rates by immigration court. Chicago is, I think, the third blue bar from the left, so it's one of the higher, has one of the higher rates in the country, and it's sitting around 20%, which means that they have an 80% denial rate for asylum seekers. And meanwhile, NIJC maintains and has for a few years now a 90% approval rate. So that just goes to show the difference that it makes for these asylum seekers to have representation in immigration court. And representing a client through NIJC does more than just support your client. We have a number of different ways that it helps the broader community as well. So NIJC, first of all, we operate on a one-for-one model, which means that every time a pro bono attorney takes a case, we're able to accept another case for representation. We've heard time and time again from our pro bono attorneys as well, the benefit that they experience by representing NIJC clients. Representing an NIJC asylum client allows you to develop trial skills. You get to develop a relationship with the client throughout the life of the case, which is a skill and a gift in and of itself. And then you learn how to manage an entire case as well. And then lastly, once a client wins their asylum, they can petition for their family members to come and join them in the United States. And they are on the road to being able to apply for their green card and potentially citizenship as well. Lastly, we have a number of different website resources for our pro bono attorneys. We have many in-depth manuals. Our asylum manual is excellent and comprehensive, and it is available on our websites. We have live and recorded webinar trainings like this one, which is being recorded and will be available on our website as well. We have a bank of sample documents that are available to you. We have a wealth of country conditions resources that are available to you, many FAQs and practice advisories, and then most importantly, we have our NIJC immigration experts who provide assistance, like I said, throughout the life of the case. And this is all available on our website. And with that, I'm going to turn it over to Josh Dunn at Better Price to speak more about the pro bono experience.
Great. Thanks so much, Liliana and Jeff and Olivia. Really happy to be here participating and talking a little bit about my recent experience handling an asylum matter with and for NIJC. So just quickly, again, Josh Dunn. I'm a litigation shareholder here in our New York office. And recently, although it took several years, had the privilege of handling my first NIJC asylum matter, in which myself and the rest of the Vetter team represented a family, a whole family. So it was a mother, her 3 biological children, her then minor, by the time we had our hearing, adult nephew who she raised in their asylum application. So after they fled El Salvador sometime in 2019, due to targeted gang violence, and the gang was MS-13, and that violence or those threats of violence were based on the husband, who was not a part of the petition. Unfortunately, he had been deported prior to the events. He was a police officer in the Special Forces in El Salvador. And so the family story was one of repeated and consistent resistance to MS-13 demands for assistance over the course of many years. So for things like uniforms, sensitive police information, favors, and the like, almost always followed by overt and direct threats of physical violence and death to his family, to the mother and to the children. So things like, repeated armed altercations on the street, including one where shots were fired, although no one was hurt, luckily. Forced entry into their home and physical assaults, harassment of their children on their way home from school, including one where one of the kids was followed and forced to take shelter in a library until the police arrived. And then sort of culminating in a note left for the family by members of the local gang. And the note was found by their youngest son, describing in graphic detail what they would do to the children if they continued to refuse the demands, including dismemberment, decapitation, really just horrible things. So, I know we only have about 5 minutes for me to kind of share my experience. I'll sort of skip to the punchline and then talk about some challenges and lessons. Our clients, thankfully, were granted asylum back in March after about a 4-year-long overall process. Judge McKenna in Chicago issued his decision from the bench at the end of the hearing, granting their asylum application, which was just a phenomenal result, obviously. I wanted to talk just really quickly about a couple of challenges and lessons, and then I'll talk about some of the rewards of this experience as well. So on the challenges side, a bit more obvious maybe, obviously there was a language barrier. So, I think initially connecting with and building trust with our clients was a little bit more difficult. Fortunately, we had some native Spanish speakers employed at Better Price who, even though they weren't initially staffed on the case, kind of jumped in initially just to do some translation and interpreting, and I think became so invested in the case that they stayed on even though they didn't have to, and showed up at the hearing, which I think was just phenomenal. And then, obviously being a case that started in El Salvador, unavailability of witnesses to corroborate statements was a pretty big issue, and we had to work hard over time to get in touch with the right people and get the affidavits that we needed. Another challenge was scheduling with the court. We had our merits hearing originally scheduled for November 2021, was postponed by the court and rescheduled by the court 3 separate times. So it should have gone forward in November of 21. We finally ended up having it in March of 23, which was frustrating, most importantly for our clients, obviously. But I think the silver lining was that we were, if anything, over-prepared by the time our clients got their day in court. We had gone through the process and had them really truly ready, and in 2 of those instances actually showing up in court before we were told it was going to be postponed further. So I think ultimately it helped us, despite the fact that it may have been frustrating. I know we'll hear a lot more about the technical elements later in this program, but I think the 2 that were big for us were first nexus. So, finding that link between the threats of violence and the fact that the father and husband was a police officer and he had been refusing to cooperate. And then the second was sort of proving that there was no reasonable and safe ability to relocate within El Salvador. I think on both of those counts, we were ultimately able to be successful because we really had the time and sort of dug deep on those questions, right? Went and got affidavits from folks in country, and just were able to kind of support those arguments ultimately in court. And then, on the reward side, obviously, those are a little bit more difficult to measure and count. I mean, it was an unbelievable experience. I think the team, which changed over time, the case was with us for so long that we had some team members depart and some new team members join. But I think it was an invaluable legal experience, both with respect to the asylum process, but also, showing up and effectively having a trial, a bench trial in court. So I think those were just unbelievable skills that some members of our team, may not have been able to get at the point in their career that they are. And then obviously, even more importantly, life-changing for the clients, right? We got to get to know this family really, really well. Got to hear the family's plans for the future, including college and careers for the kids. One of them in particular was telling me all about how he wanted to become a veterinarian, and got to see the look of relief in their eyes when they realized this years-long legal battle was over and they were safe and they no longer had to worry about deportation or MS-13. So I would absolutely take on more cases. In fact, I have a new one where we're, unfortunately, unlike a lot of the cases I think the veteran has right now, we're waiting on a merits hearing date, but we're continuing to work with the client and prepare the papers and draft the affidavits. And so I absolutely enjoyed my experience. The NIJC staff that we worked with were phenomenal. Pleasure to work with. The resources were amazing. And so it was really a great experience for me and for our team, and I appreciate it, and I'm happy to answer any questions that anyone might have before we move on.
Thank you so much for sharing, Josh. That was really enlightening and inspiring to hear from someone who has really been through the whole process as a pro bono attorney with NIJC. And congratulations to you and your clients on the win. That was really wonderful to hear about. We do have a chat. Feel free to, for those of you who are virtual, can drop questions in the chat as we go. We will respond as we can. We will also have some time for Q&A at the end. I am going to now pivot and take us through some of the basics of asylum law before I pass things over to my colleague Jeff, who is going to give you the nitty-gritty breakdown. I am going to start us out with the overview. To start, let's take a look at who the players are. Who might we be interacting with over the lifespan of an asylum case? First, of course, is the asylum seeker, your client and their family, and then you as the attorney or as a team of attorneys. If your client is in removal proceedings, has a case before the immigration court, then you are interacting with the Department of Justice, which houses the Executive Office for Immigration Review, or EOIR, which includes the immigration court and the Board of Immigration Appeals. If your client encountered, maybe entered at the border and has had an encounter with Customs and Border Patrol, or any encounter with ICE, was in detention, then you are interacting with the Department of Homeland Security, which oversees CBP and ICE. When you show up at that merits hearing, opposing counsel, those are going to be ICE attorneys. And then if you are applying for a work permit for your client, that application goes to USCIS, or U.S. Citizenship and Immigration Services, which is also housed under DHS. Finally, we are focusing today on defensive cases in immigration court. But if you take on an affirmative case where your client is going to an asylum interview, the asylum office is also housed under USCIS, which is part of DHS. If you are working with an unaccompanied immigrant child, you might also be in contact with ORR, or the Office of Refugee Resettlement. As you can see, there are a lot of players here, and it's really helpful to our clients to have support and a strong advocate when navigating all of these different systems. I'm going to read out the definition of asylum so that we can all have it in our heads a little bit before we get into that step-by-step breakdown. An individual is eligible for asylum if she meets the definition of a refugee. And that definition is any person who is outside any country of such person's nationality and who is unable or unwilling to return to, and is unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. And this has its basis in international law from the UN protocol relating to the status of refugees. When we are preparing a case, we are looking for law and legal sources to support our arguments, and there are a few different places we look. We look to the INA, which is the Immigration and Naturalization Act, which has parallel citations to Chapter 8 of the US Code. The regulations under 8 CFR, the Code of Federal Regulations, these are binding in all immigration. And then there's case law, right? There's only one Board of Immigration Appeals for the whole country. So published BIA decisions are binding on all immigration courts unless they conflict with the Court of Appeals that has jurisdiction over that court. So for most people, most NIJC cases are in the 7th Circuit. So we can use BIA case law unless the 7th Circuit has rejected it. And as it happens, the 7th Circuit has rejected quite a bit of BIA case law in ways that are often really helpful to us and our clients. So when we are putting together a case, we want to be starting with 7th Circuit case law, and for the most part, staying within our circuit, right? If the 7th Circuit is silent on an issue, we might look elsewhere, but for the most part, 7th Circuit case law is our friend. We want to be focused there, and we can, always take a look, but for the most part, we are not leaning on other circuits in making our arguments. When someone enters the United States and wants to seek asylum, they have 1 year to do so. This is really important. Not only does an asylum seeker have to meet the refugee definition, they have to prove that they have timely filed their application within 1 year of arrival. So if you are taking on a case that has not yet had the application filed, that is a date you are going to want to mark on your calendar, and you are going to want to be checking to make sure that we really know when that person entered, right? Sometimes people, if they did not present at the border, might not know or have the exact date, and we want to make sure we are filing with room for error to make sure we are firmly on the correct side of that 1 year deadline. There are a few exceptions for extraordinary circumstances or changed conditions that we'll talk about later, but they are difficult to get, and we don't want to have to make those arguments unless we absolutely have to. This is what the asylum application looks like. It is called Form I-589. It is available on the USCIS website. We also have a link to it on the NIJC website. Even though we are using shorthand here, right, we say the asylum application. When we fill out this application, we are actually applying for 3 forms of relief. First, asylum. Second, what's called withholding of removal, which you can see on the top of the form. It is the application for asylum and withholding of removal, and we will talk about what this means in just a moment. And then third, we also have the option to apply for relief under the Convention Against Torture. You can see where this is circled on the first page. There's a box you can check. There's also a box on page 5 to be checked to apply for what we call CAT relief. We check it on every case because we want to preserve all claims to relief. Statutory withholding is similar in many ways. It's similar to asylum, right? Similar elements, but it has a higher burden of proof. Whereas someone seeking asylum only needs to, the burden of proof is a reasonable possibility or greater than 10% chance of persecution. Withholding requires this higher standard of clear probability or greater than 50% chance of persecution. But like asylum, we're looking for persecution perpetrated by the government or an entity the government cannot or will not control on account of one of those 5 protected grounds. We also have that box we can check, right, for CAT relief. And CAT relief is a little bit different. It also has the elevated burden of proof. Like withholding, it's a more likely than not standard. But unlike withholding and asylum, there is no nexus requirement. You do not have to show that your client will be tortured because of one of those protected grounds. We just have to show that there is this more likely than not risk of torture by or with the acquiescence of the government. I will note that torture has a specific legal definition. So if you're making this argument, you're going to want to look for case law and you're going to want to match what the risks are to your client with how torture is defined. And on the next slide, we have a comparison, right, of these forms of protection. We request them all, right? We want to preserve all forms of relief, but we are always aiming for asylum because it is the most achievable with that lowest burden of proof, and it has the most benefits for our client. As you can see here, it's that reasonable possibility standard. It is a path to citizenship. It allows the recipient to petition for family, to travel abroad and return to the United States, to access FAFSA. It has really strong long-term benefits. Withholding and CAT protection, in addition to having that higher standard, do not have the same benefits. So if you're sitting here thinking, why would anyone get withholding or CAT, right, when asylum is available? It could be that they didn't meet their one-year deadline and they are barred from asylum because there's no exception available. There could be like a criminal conviction or another discretionary barrier to asylum because asylum is a discretionary form of relief. Withholding and CAT are non-discretionary, so as long as we can meet that standard, the adjudicator does need to grant them. Because of these differences, like I said, asylum is always the goal, but we are putting forward all claims to relief, both in that initial I-589 and in our briefing. Having given you that brief overview, I'm going to pass it over to Jeff to give you the nitty-gritty breakdown.
Thank you, Olivia. Yeah, and so as Olivia, I'm sorry? Yes, please. What exactly is withholding? Mm-hmm. So yeah, as Olivia was saying, withholding is another form of protection against removal from the United States. So it would essentially prevent the U.S. government from removing you to your country of citizenship, which would mean you could stay in the United States indefinitely and you can renew your employment authorization during that period of time. It doesn't have some of the other benefits that accrue to asylees that Olivia touched on. And so it's a less desirable form of protection, but if you're not eligible for asylum for some reason, it could be an effective backup. Yes.
I have two questions. So my first question is, if they're not approved for asylum, are they given like a deadline for them to leave the country? And then my second question is there any chance that these documents are viewable by other people, especially people like in MS-13 or something like that, to where there would be a danger?
So the two questions were one, if you do not receive any form of relief, is there a timeline in which you have to leave the country? And then the second is whether the proceedings of asylum case would be confidential or otherwise viewable to groups like the persecutors in home country. And the first answer, we'll say generally yes, without going into details. There's a certain amount of negotiation with the government that can go into figuring out options for leaving the country, and it's going to vary a bit case by case and what the government's priorities are at a moment of time. I'll also say that there is an opportunity to preserve appeal at asylum hearing, and if your case is not granted, we generally do advise to preserve that appeal, which would stay the removal while the appeal is pending. In this second instance, there are regulations making asylum proceedings confidential. So something would have to go very, very wrong in the government's file management for that information to become available. And I like that people have jumped in with these questions because this section is going to be a little bit more interactive. We are going to have, so as Olivia said, we're going to be breaking down the parts of the asylum definition. going piece by piece, but we're also going to be talking about how these legal concepts apply to the facts of an example case. And that's where we're hoping everyone can kind of jump in with their thoughts and, and have some open participation questions coming up in a moment. So this is good. Keep up that enthusiasm. And so taking the asylum definition that Olivia read, through various court cases, it's pretty clearly been broken down into 5 elements. And each of these is crucial. Each of them has to be met for asylum to be granted. So the asylum seeker needs to show a well-founded fear of persecution perpetrated by the government or an entity that the government cannot or will not control on account of one of 5 protected grounds: race, religion, nationality, political opinion, and membership in a particular social group. And even though this is all interconnected, right? This is all describing one singular set of experiences and reasons for not being able to return to the country. Each of these elements needs to be kept logically distinct from the others because there is case law that elaborates the legal standard for each of these elements. And we have to be mindful of meeting the legal standard on each of these 5 pieces. And so what we're going to do now is just go through them one by one and kind of articulate what the standard is currently. And for at least 3 of these, we'll look at how they apply to the facts of a case. So well-founded fear. Key thing to focus on here is well-founded. Right? It is the asylum seeker's burden of proof to show that they have a well-founded fear. And the well-founded part means there's a reasonable possibility of future persecution. The standard that Olivia said before. Note that that is, again, lower than the standard for withholding or CAT. We're not talking about more likely than not, right? We're talking substantially lower than that. And in fact, the Supreme Court has glossed the standard as a 1 in 10 chance of persecution. So remember, that's where the bar is. You just have to show that there is that reasonable 1 in 10 possibility. There's 2 ways of establishing it. Either past persecution or a reasonable possibility of future persecution. In a lot of cases, there are strong arguments for both past and future persecution. First thing to know is these arguments are in no way mutually exclusive. You can argue both at the same time. It is usually strategically a good idea to argue both at the same time. And so if the facts support it, we would always advocate to argue both past persecution and future persecution. Going into that a little bit more closely, past persecution means that your client has experienced harm or harms in the past where all of the other asylum applications are, all the other asylum elements are met. So it was by an entity that the government is part of the government or that they will not control and is on account of a protected ground, and it rises to the legal standard of persecution that we'll talk about in a second. If you can show all of that relative to their past experiences, you then have a rebuttable presumption of future persecution. So if you establish past persecution, then you succeed on the claim unless the government can show there have been changed circumstances, so something fundamentally has shifted that would make the country safe to return to for this particular person at this point in time, or that there's a safe, reasonable internal relocation option. So, imagine a very large country, many cities, a persecutor that's confined to one area, and a client who could reasonably live in a faraway city and not have any interaction. And the key word here is reasonable, right? It's not just that another part of the country exists that would be safe. It's that it would be reasonable to expect this individual, given all their circumstances, their education, their training, all aspects of their identity, it would be reasonable to expect them to be able to live somewhere else. So that's what past persecution looks like. For future persecution, first, we need to show that it's a subjectively genuine fear, right? They actually are afraid of going back to the country. And so that part comes to credibility, but as a legal standard, it's very straightforward, just that they really feel this way. And then it has to be an objectively reasonable fear. Objectively reasonable means it is well-founded. It means the 10% chance all other asylum elements need to be met. And there has to be no safe, reasonable internal relocation option. So there's a little shift in burdens here, right? We said before, if past persecutions establish burdens on the government to show that a safe, reasonable internal relocation option exists. If we're doing future fear only, then burden is going to be on the applicant to show that none exists. Which is functionally a very similar line of argument. It's just that there's that little shift in where the burden falls. You show all of that, you have a well-founded fear of future persecution. Now, what is persecution, right? Because that is what all this is about. We fear persecution and or have experienced persecution. And so what does that mean, legally speaking? The Seventh Circuit has a fairly clear standard that's essentially consistent with most other circuits, but it's, I think, particularly clearly articulated here in the Synoikova case that you see on the screen. And it articulates 3 types of persecution. So there's significant physical force against a person's body, the infliction of comparable harm without direct application of force, or non-physical harm of equal gravity. And so significant physical force is conceptually straightforward. The infliction of comparable harm through non-physical, without direct application of force. An example would be locking someone in a room without access to food and water, right? It's actually physical harm that you inflict in the form of hunger and thirst, but not via force. Non-physical harm is where there's, I think, the most space to analogize and look for other examples. The examples that are given directly by the Seventh Circuit are an immediate credible threat of death, so threatening to kill someone while holding a gun to their head, that kind of thing, or refusing to allow someone to practice their religion could be a non-physical harm of equal gravity. But these things can be analogized, right? Other threats that aren't holding a gun to someone's head, there's room to argue at what point they rise to this level of persecution. And another kind of analogous situation that has come up in some cases would be someone who's forced to live in the closet or not live their gender identity, right? That could be another type of non-physical harm. And so the key thing here is, when you don't have that significant physical force, you need to look at what the client has experienced and think of how to analogize it to some of the acknowledged examples, or how to draw the comparison to that significant level of physical force. Brief note that for children, the standard can be a little bit lower for persecution. And the big thing, though, here is that harm has to be considered cumulatively. So a lot of people have been through many experiences, and when the court is looking at persecution, it has to add all those instances of harm together rather than taking one in isolation. And so here's our first look at our case example. I'm going to read through it this time. We are going to return to it several times, 2 more times in the first part, and then 2 times in the second part of today's presentation. So take a minute to read it. I'll also read through it, and we'll be coming back to this. So Patricia is a woman from Haiti. Growing up, Patricia's father was a leader in a political party, and Patricia helped to support the party's campaigns when possible. Patricia's family received many threats due to their involvement, and one day a group of armed men came into their home, beat up Patricia's father, put a gun to his head, and threatened to kill him and his family if he continued his political involvement. When he did not quit his political party, his family continued to receive threats. Later, a previously incarcerated gang member forced Patricia into a relationship with him. For several years, he regularly raped and tortured her. Eventually, Patricia escaped and moved to Chile, where she lived for a few years with her father and her children. However, Haitian migrants were regularly attacked in Chile, and after Patricia's children's father began to abuse her, she fled to the United States with her daughter, Odette. So the first question we look at here is, what facts occurring in Haiti are important for establishing persecution? Yes.
That she helped with the political party, that she received many threats, that she had the connection with her father, which could also.
So first we have connection to political party, receiving many threats, and connection to her father, which are all key parts of this case. And it should have been a little bit more specific. When I say what's important to persecution here, I mean what is important to establishing the degree of harm rises to persecution. So out of those first three examples, I think definitely the threats are going to fit into that. And we're going to need to know more information about exactly what kinds of threats they received, whether the threats were directed at Patricia, and see if they rise to that standard for the non-physical harm. What other example or examples do we see here? Yes. And I apologize, I had a little bit of a hard time hearing, but I believe you said first the harm directed toward the father, and then the rape and torture by the gang member, right? Yes, yeah. And I think, and all of that is correct for the threats that are directed at the father. One thing I want to specify is that we need to show that they are also somehow directed at Patricia, or potentially harm inflicted on the father with the purpose of causing harm to her, right? So if you harm someone's family member, really hoping to get to that person rather than the family member that you're directly harming, that can qualify as persecution, right? So I mean, it just has to be tied. The threats need to be tied cleanly enough to Patricia. But then the other part of what you're saying is absolutely right. The previously incarcerated gang member, the repeated rape and torture would certainly rise to the standard of persecution. And I apologize for moving on, but just in the interest of time, I'm going to move to the next element, and we'll also have a question for this one, returning to that same example. So the persecutor. The entity committing that level of harm we just talked about needs to either be a governmental entity or one that the government is unable and unwilling to control. And we say governmental entity, that can be at any level of government, right? It could be the national police, it could be the military, or it could be a local mayor, some other kind of local legal authority, a village chief. In many instances, groups that are formally outside the government but exercise government-like control or are imbricated with the government to a high extent could be considered government entities. So paramilitary groups are a sort of classic example. In some cases, gangs could be. Think of a very large gang that is influential in local elections, that bribes many officials, that is has people in the police department, right? That is so entrenched in the government that it acts as part of the government. Or it could be just an entity that's not part of the government, but the government has no control over it or isn't willing to exercise control. So again, gangs fit this scenario. Guerrilla groups can opposing political parties, even private individuals like members of someone's family could count. Think of a situation where the government either has no laws preventing domestic violence, right? And so the government is unwilling to prevent that type of persecution from happening. Or just maybe there is a law, but it's just never enforced, right? That would be another situation where the government is unwilling to control the persecutory conduct of private individuals, and that would fit into this framework. So key thing takeaway, it does not need to be the state. You need to relate the persecution to the state, but it does not need to be a state persecutor. And so looking back at Patricia, and again, focusing on the events in Haiti, who are the agents of harm here? Good, the political opposition.
Gang members.
And the gang members, good. That's absolutely right, the political opposition and the gang members. And let's see. And so what would we need to know about the political opposition and the gang members for us to know whether we've just met that third element standard? Yes, Mark.
You need evidence that she tried to go to the police, and would you also need a country condition expert to testify about rape victims in Haiti?
Those are great suggestions. So again, for the folks online, the question is whether she would need to show that she has gone to the police, and whether it'd be helpful to have a country conditions expert here. And so just to frame it more broadly for everyone, what we're getting to here is we need evidence that the government was unable or unwilling to control both this political party and this gang. And these are ways to potentially show it. One would be to show that she went to the police were unable to help, maybe even told her they were unable to help, or they just refused to take a report, or whatever happened. Yeah, that she sought protection and was denied protection would be one way to show this. Under recent Seventh Circuit case law, there are some discussions of this particular aspect, the need to go to the government. And generally, you would need to show either that the asylum seeker did seek protection and was denied, or that doing so would be futile, right? So I guess the direct answer to the question is there's not a firm requirement that someone try to seek protection and be denied in order to prove this element. But if they did not seek protection, then you need to present evidence that shows that doing so would not have been effective, right? And so that just is a different pathway to get there. And in terms of what kind of evidence would be helpful in showing that going to the government for protection would be futile, that's where the suggestion of the country conditions expert, I think, is very well taken. That it will be things that your client can tell you, it will be things that their family can tell you, and direct evidence of that nature. But the work of experts on that country, and particularly an expert who would be willing to provide an affidavit and or testify at the hearing, can be very effective in showing that there really is no protection for someone in this situation, right? If this gang is threatening you, for example, let's say the gang, like everyone knows that if you report the gang to the police, that's as good as telling the gang themselves that that you want to report them, right? They're so ensconced in the police that that it will come back to them. And if everyone knows that, and that's the reason why she wouldn't have reported it, that's something that an expert could testify to. So yeah, great. So again, we just need to prove that government unable and unwilling to control, and look for all forms of evidence that show that. Last two elements, and then we'll come back to this hypothetical one more time. So, and we have to keep these two separate. It's very tempting to collapse this and the next element together. In fact, if you read opinions by immigration judges, the Board of Immigration Appeals, the Seventh Circuit, you often see them collapse together as one element, but they are logically distinct and they do have separate standards. So we need to keep them apart. So the persecution has to be on account of a protected ground, and on account of the causal link is an element in and of itself. And we refer to it as nexus, right? The causal nexus between the persecution and the protected ground. And here the standard is at least one central reason for the persecution, right? So that means not the only reason. Persecutor can have mixed motives. They can be targeting someone both because that person knows them money and on account of their religion, right? And you can argue that the persecution is on account of the protected ground of religion, even if there are other motivations. And again, one central reason, take the verbiage of that standard to heart. It isn't saying the main reason even. It is just saying one central reason. Also, in terms of showing this from an evidentiary perspective, often circumstantial evidence will be most effective. As Josh said before, sometimes persecutors do actually send you a letter saying this is why we are harming you, right? And if you have that, you still need to make the connections between their valid reason and one of the protected grounds. But that can get you a long way towards showing nexus. In many cases, though, I would say the majority of cases, the persecutor doesn't articulate it that cleanly. And so you need to look into circumstantial evidence of their motives, right? What did they say? How did your client understand the person's motivations? Why did they understand it that way? Is there anything in the country conditions that helps explain that people in the situation are generally targeted on account of a protected ground? It's going to be very case specific what that circumstantial evidence is. But very often that is the key to proving nexus, is finding strong circumstantial evidence. Now, for the protected grounds, like I said, there are 5. And the first thing I want to highlight is they are not all based on political opinion and political belief in a direct way. In other words, people often refer to asylum as political asylum, and that's something of a misnomer, because asylum can be based on a protected ground other than political opinion. And so just to give some examples of cases we've had recently, so you can see like the types of grounds that come up pretty commonly. We have a man from Mexico and his family who are targeted by a cartel when he refused to join, a man from the DRC and his family who are targeted by police due to his political activities, a woman from Cameroon who fled an abusive relationship and was trafficked internationally before escaping to the United States, and a gay man from Colombia who fled to the United States after facing years of abuse and discrimination for his gender presentation and sexual orientation. Right, so all of these can be very strong asylum claims, and only one specifically is due to political activism. Going through the grounds one by one, race, just want to flag that it's maybe a slightly different definition of race than in some other legal contexts. It has a broad meaning, can refer to certain language and ethnic groups as well, and nationality similarly can also apply to ethnic and linguistic groups, and there's a little bit of overlap in how those two concepts can be applied at times. So those are slightly broader concepts than where you may see them in other places. When we talk about religion, it's not just having a different religion from your persecutor that you're not allowed to practice. It could be having the same religion and being forced to practice it differently, or it could be not practicing a religion and being forced to do so, or being jailed for being an atheist, for example. For political opinion, key thing is that it can be actual or imputed. In other words, you don't have to actively take a position against the government. It's enough if the persecutor thinks that you're taking a position and persecutes you on that account. So maybe one of your relatives is politically active and you're targeted for that reason. or you criticize some aspect of policy, but and that's just inferred to be opposing the party in power. The last category is the most complicated one, particular social group. We have a whole separate training on this on our website. There are a lot of weeds we can go into, and we are not going to go all the way into them. Essentially, we're talking about a group of people who are joined by some common standard that they, common trait that they cannot or should not be made to change about themselves. And in some circuits, in most circuits, there are additional criteria of particularity and social distinction that we won't go into here because the Seventh Circuit does not recognize those additional requirements. But in general, it's a subset of society that are joined by some common trait, and it's an immutable trait. So it could be based on gender, so Salvadoran women and girls, for example. It could be based on family membership, the immediate family members of whatever person, if that's why they're being targeted, just because they're part of that family. A case that was, or a particular social group that was upheld by the BIA, Board of Immigration Appeals, about 10 years ago is women of a nationality, let's say Guatemalan women in intimate relationships, they're unable to leave. And various slight variations on that, or in marriages, they're unable to leave. There's a Seventh Circuit case, Sarhan, that is Jordanian women who have disobeyed gender norms. And the idea is once you've disobeyed deep set gender norms, that past action is undoable, right? It's something you've done and you're kind of forever marked by having disobeyed those norms. In some instances, opposition to gangs or witnessing certain types of criminal activity can also be a basis for a particular social group. Former employment in some cases will also work. But the key thing to take away here is to really get to this aspect of the claim. You need to dig into the case law and kind of think creatively about how your client's situation compares to other groups that have been held up in the past. And so realizing that we haven't dug into the case law here and we're just looking at this at sort of 1,000-foot level, want to see what suggestions you have about what protected grounds might apply here or what facts might be relevant to figuring out the relevant protected grounds for Patricia.
That had a particular political opinion.
Okay, good. Yes, family membership. And so her father was politically active, received threats on that basis, and in principle, that could be a family-based particular social group, so immediate members of that family. Depending on the facts, it could also be an imputed political opinion. Maybe they're receiving threats because the opposition party sees them as all, politically active by virtue of their relationship to this person. So it could be an imputed political opinion as well. Good. What else? Yes.
For gender, that she's a
Yes, excellent. Yeah, and so that suggestion was that there could also be a gender-based particular social group here, and that is absolutely right. And I think particularly when you look into the actions of the gang member, I think we would need more facts to know exactly what particular social group would apply here, but something along the lines of since she was in a forced relationship and was being targeted on that basis, something along the lines of what we saw before about women in relationships that aren't able to leave might be applicable. Good. All right, and with that, thank you for the participation, and you have more opportunities to jump in and talk about Patricia's case a little bit later after the break. But we are going to take a 10-minute break. Before we do, I want to give you our first CLE word of the day. So make sure you mark this down. And it is list. As Lily mentioned, we have a list of cases that we would love to have you all jump in on now that you are acquainted with all the basics of and all the elements. And so list is the CLE word. And when we come back, we will talk about working with your client and kind of putting all the filings together and how you actually present the case. So get more into those practical details in about 10 minutes. Thank you. All right. I think we are ready to resume, and I will turn it over to Olivia to do that in a moment. But just first, out of curiosity, we were wondering how many people here have already done asylum work before this? Okay. All right, so we've got a few people. It's good. It's good to see. Okay, and for our second section, we're going to start off with talking about getting started with new asylum cases. And for that, I'm going to turn it over to Olivia.
Thank you, Jeff, and welcome back from the break, everyone. I hope you're feeling refreshed now that you have a basic understanding of asylum law. And as far as I am concerned, you are ready to take a case. You've heard about our list and need a representation. Let's talk about what that representation would actually look like. On the next slide, we're going to go back and do a quick refresher of all of the players in an asylum case now that you're oriented. There's going to be your client, the asylum seeker, their family, you, the attorney. And if that case is in immigration court, you are getting ready to present that hearing before the immigration judge at the immigration court under the Department of Justice. You might be applying for a work permit with USCIS under the Department of Homeland Security, and you might be having other interactions with ICE or CBP, requesting records if your client has been in detention or had other contact with those agencies. Finally, if your client is an unaccompanied immigrant child, you might be in contact with the Office of Refugee Resettlement. Here's a roadmap of the lifespan of an immigration case, all the venues where it can be. When we are starting a case, right, we want to know the posture. Where is this case? Who is adjudicating it? For the majority of cases we are talking about today, those are defensive cases. We're over in this right-hand box with the red title, individuals who have a case in immigration court and who are seeking asylum as a defense to deportation. However, there are also affirmative cases. There are folks who maybe enter without inspection, never have any ICE or CBP contact, folks who enter on a visa, and who, rather than applying for asylum as a defense, they are affirmatively requesting asylum with the asylum office, which we remember is part of USCIS. So NIJC also has affirmative asylum cases. It is not the focus of our presentation today, but if you're interested in them, send us an email, let us know. We're happy to talk about them. We do have them on the case list. When someone is in affirmative, sorry, I'm going to stay on that slide for a second. Thank you. When someone is in affirmative asylum proceedings, their case is adjudicated by the asylum office. The asylum office cannot order someone deported or removed. What happens after an asylum interview is either the person gets an asylum grant, or if the asylum office cannot grant and that person does not have another form of status to fall back on, then the case is referred to the immigration court where they can again present their asylum case to the immigration judge. It is a second chance to make that asylum claim. Immigration judges in general have more discretion and tend to feel more empowered to use their discretion than asylum officers. So just because a case didn't win at the asylum office doesn't mean that it cannot be a winning case in immigration court. If we don't like the outcome, or if DHS doesn't like the outcome of that hearing in immigration court, either side can appeal to the Board of Immigration Appeals. And again, if either side doesn't like the outcome, they can appeal to the Seventh Circuit. Most of the cases, like I said today, are staying in this defensive area. They will be in immigration court when they come to you as a pro bono attorney. They will likely be resolved in immigration court, but we do work with the whole spectrum of cases. We have affirmative cases available. We have cases on appeal that pro bono attorneys also can be involved in. Now I will go to the next slide, which just reiterates that the purpose of this training is to focus on those defensive cases. But we do have excellent resources on affirmative cases in our asylum manual, and we also are available to talk about them directly if that is something you're interested in taking, as we do have affirmative cases in need of representation as well as defensive ones. When you are starting a case, you're going to want to know, what is the posture of this case? Is it a defensive case? The easiest way to know, I will just tell you, is it's in our case descriptions. If you are looking at our case list, it will tell you where the case is venued. The other way to know, and a document that's really important to have if your client is in removal proceedings, is the notice to appear. The notice to appear is the charging document that initiates removal proceedings once it is filed with the court. You're going to want to check, usually we have it in the case file. If for some reason the client doesn't have a copy of their NTA, it wasn't given to them, it was lost, you can file a FOIA request to get it. Notably, as I said, removal proceedings aren't initiated until the NTA is filed with the court. I'm going to talk in a couple of slides. We have started to see some people usually who present at the border and are given an NTA, and then the NTA is not given to the court until months or maybe over a year later, and that can put them in a little bit of a funky place procedurally. At this time, we are trying to get those procedural questions resolved before putting folks on the case list, so this shouldn't be something that most pro bono attorneys will be seeing, but I do want to put it on your radar because it does happen and they do occasionally show up on the case list. When we initiate a case, we do the intakes, we put out those case descriptions, you look through our case list, you find something that you think is going to be a good fit, conflicts clear, here's where you start. One, our procedural manual for asylum representation. It is very thorough, it is very detailed. If today is the high-level crash course, that manual is your document to go return to throughout the life of a case for detailed step-by-step instructions. What am I doing during this meeting with this client? What is it going to look like when I show up at a master calendar hearing? What kind of information needs to be in the affidavit? All of that information is in there. It's on our website. I highly encourage you to give it a thorough read through before starting a case and then to return to it as you continue to work with your client. You are also going to want to review the case file. When we transfer over a case, we send all of our notes from our intake. Maybe we've been working with that client for a year or more. So any other updates, any information we have, copies of work permit applications we filed, any corroborating evidence that client has already given us, we're going to send that to you. You're going to want to review that in detail prior to meeting with the client. You can always ask us. Sometimes we have people reach out and say, hey, I saw that it mentioned this client had a brother who was there when they were attacked. Should we contact them for a letter or an affidavit of support? And we'll say, yeah, like, yes, go for it. But that's a good place to find that kind of information is in the case file. And having a good handle on it before meeting with the client shows a lot of respect for the case, a lot of familiarity, reassures the client that they're not starting from zero with you, that you've taken the time to review and get familiar with all of the knowledge about the case that is already available to you. Then, if your case is with the immigration court, the NTA has been filed, you need to file an appearance with the court to make sure that you're getting notified about any upcoming hearings, any changes to hearings. You want those notices coming to you as well as to your client. To do that, you file Form E-28 with the immigration court. we'll talk in a minute. There are online filings, there are paper filings. You're going to want to get on record though as quickly as possible. But before you can do that, if you've not appeared in immigration court before, you have to register. You go through this e-registry process. The link is in the PowerPoint. We can also send it to you. And it's a pretty quick online form. And then you'll need to go to the court in person with an ID to verify your identity. To verify your identity. As this is mentioned here, up till about 2021, everything with the court was on paper. So if you are working on a case that was initiated prior to 2021, you are giving the court paper filings. Everything has to be on paper. The court will not accept anything else. If you are filing a more recent case that is in the ECAS system, then you are submitting filings electronically through ECAS once you create an account, and the court will not accept a paper filing. Don't even try, they will send it back to you. So it's really important, and your NIJC point of contact can work with you to figure out what type of file, what type of system you're using. But either way, you want to get that appearance on file right away. This is a handy tool. Like I said, we are trying to get cases sorted out procedurally before placing them, but this tool is helpful even if you know that your case is, the NTA is filed and your case is venued with the immigration court. The automatic case information system and the accompanying hotline both provide information about the status of immigration cases by entering the A number. If your NTA is not filed, you want to be checking this every 2 weeks to see if your client comes up in the court system. When you enter an A number, basically 3 things can happen. 1, you get a page with the client's information that says when their next hearing date is. 2, you get the page with the client's information that says there is no hearing date. Or 3, you get an error message that says no match for this A number in the system. If there is no match, that generally means the court does not have your client's file, the NTA has not been filed, your client may have an NTA, but the court doesn't know about it, removal proceedings have not been initiated. For clients in that posture, we check ACES every 2 weeks. We want to know when that NTA is filed and jurisdiction is with the court. Even for cases where the NTA is filed and our client shows up normally in the portal, I would still check at least once a month. As Josh mentioned, hearing dates change. Sometimes it shows up in the portal before the mail out notice makes it to you, and checking regularly can give you a head start and give you a heads up about anything that might have shifted. The other piece that you're going to want to do when you first take a case is get those important dates on the calendar. So what does this mean? First, if the I-589 isn't filed, we want that 1-year deadline on the calendar. 2, if it is filed, as we'll talk about later, asylum seekers can apply for work authorization 150 days after their I-589 was filed. So you want that date on the calendar as well. We want to be helping folks get their work authorization as quickly as possible because it is really helpful to the point of being life-changing for our clients to have access to work authorization and a social security card. So you want your 1-year deadline, you want your EAD eligibility, your work authorization eligibility. You want to know if you have a hearing, right? Is it a master calendar hearing, which is basically a status hearing, a time when the judge is going to assign you for a merits date, make sure that everything is in order with your case? Or do you have a merits hearing where you are going to be presenting the merits of your case? We want those on the calendar as well. If it's a merits hearing, you want the filing deadline on the calendar too, right? And the default filing deadline is 15 days before the hearing. But please note that some judges have their own system. Some require 30 days. Some might make a different request. So make sure you're in contact with your NIJC person to make sure you know what it is, both to have it calendared and to make a plan for review, right? We review materials, that is part of our job. We are happy to do it. The more time we have to review, the more thoughtful and thorough we can be. Let's think back a moment to that slide we've seen a couple of times with the many players in the immigration system. If our client has had significant contact with any of those agencies, ICE, Customs and Border Patrol, USCIS, before coming to us, we want to know what records are out there. There is no discovery in immigration proceedings. So if you want to know what information the government has about your client, you need to file a FOIA request with the appropriate agency. NIJC can help you figure out if and where and how you might need to file that, but that could look like a FOIA with USCIS. It could look like if your client has had previous hearings, getting the file and the recordings from the court. It could look like for an unaccompanied child requesting the file from ORR. Biometrics. Biometrics is just a fancy word for fingerprints, but it is a really important part of a case. An asylum judge cannot issue an asylum grant unless they have up-to-date fingerprints for your client in the system. So that means we need to make sure that they have those. We've seen judges, if fingerprints aren't up to date at the time of the hearing, postpone the hearing for months or even more than a year. We've also really frustratingly and kind of scarily in other circuits seen judges try to just deny asylum for asylum seekers who did not have their fingerprints complete at the time of the hearing. So this is something really, really important to make sure you have a handle on. Pretty much as soon as you get that case, you're going to want to check with us. Has a biometrics request already been filed? The case itself is with the immigration court, but it's USCIS who does the fingerprinting. So what we do is we send a packet, we send a letter to USCIS that says, hey, here's proof that my client is in immigration court. They have a defensive asylum case. They need their fingerprints done. Then USCIS sends a notice. Your client goes in. It's a quick appointment, but a very important one. And it is necessary to request in almost all cases. The one exception is if your client had an affirmative case with the asylum office and they were fingerprinted. In conjunction with that, those fingerprints stay with them if the case is then referred to immigration court. But do not get confused. You might be thinking, my client was fingerprinted at the border when they arrived, or my client was fingerprinted when they applied for a work permit. Surely the government can share those fingerprints amongst its agencies, and the court has them. The court does not have them. Do not count on those. The court does not have them, and those will not count as fingerprints associated with the asylum case. So as you can see here, check with your NIJC point of contact, make sure that you have fingerprints, make sure they are current before the hearing. We can help guide you through that, but make a mental note. It's also in the manual. This is a quick and in some ways minor, but extremely important step of the process. With that, I am going to hand this over to, yes?
Olivia, real quickly, it looks like we have a question in the New York office. Do you have a minute? Can we ask that question now, or should we wait to the end?
We are
a little over.
A little over, but we can also, I'm happy to try to answer quickly, or we can, I think waiting till the end might be best, or if folks drop things in the chat, I'm trying to respond as we go.
New York, do you want to unmute and ask your question?
Hi, I just wanted to flag that the links in the PowerPoint weren't working. So if you could send us that manual and all the other links on that slide on page 22.
We can do that.
Okay, thank you.
Was that the question, or was there a separate one, biometric specific?
We have a question in the room right now, so just a second. She'll ask the question and we'll repeat it.
We had the biometrics done before the case came to us, but
the speaker said it needed to be current. Do we need to update it? Does it go stale after a certain point in time?
Is there an expiration on the biometrics and how long are they valid for? Or when would you need to update?
They can typically be refreshed. There is an email account for opposing counsel for the ICE attorneys where you can email and say, hello, are prints current? And they will refresh them. So clients don't generally have to go back and get reprinted, but they may have to like rerun the records based off the prints they already have, if that makes sense. So when someone's working on a case, we do share that email to check in and make sure prints are on record and have recently been refreshed prior to the hearing.
Thank you. We can move along for right now. We have a little time at the end for Q&A, if that's all right.
Okay, so now that we have gone over asylum law and the first steps of your case, we are going to talk a little bit about working with your client. So first of all, this is just throughout the duration of your case from the very beginning to the very end. You always want to be keeping in mind your filing, and there are three main elements to the filing. There is the affidavit, your corroborating evidence, and your legal argument, all of which lean on and support one another, and then all of which center around your client's claim and their lived story. So briefly, first of all, NIJC's clients are all in the United States seeking protection because they are afraid to return to their home countries. We represent individuals from all over the world and all walks of life. Some of our clients are very highly educated. Some of our clients have little to no education or are illiterate. And most of our clients have gone through incredibly traumatic events that have left them physically and emotionally scarred, and that is why they're here seeking protection. Because of the traumatic events that our clients have experienced, there are a few ways that their trauma can manifest when you are working with them. One of those ways is faulty memories. It's not uncommon for our clients to have gaps in memory or maybe inconsistencies, particularly surrounding violent events. So that's something to keep in mind when you're doing prep sessions with them for affidavits or testimony. So you might want to schedule some extra time, start preparing in advance in anticipation of any issues that can arise from that. Discussing violence can also be difficult for many of our clients, especially clients who have experienced gendered or domestic violence. So it's important that you have a roadmap for clients that they're aware of when they're going to need to discuss that with you and why, and you handle sessions like that with particular care and attention. Many of our clients are also in very vulnerable situations in the United States. Housing might be unstable, access to food might be unstable, work schedules might be erratic. So immediate needs like housing, food, income can often seem more important to our clients than case preparation, which is going to be your main priority as their pro bono attorneys. So understanding what your client's priorities are and developing a plan to navigate that so that you can continue to work on their case and it's not going to impact your work together is going to be important as well. And then lastly, family dynamics are often complicated for asylum seekers. Say you're working with a family unit, or maybe you're working with a child who has a complicated dynamic with their guardian. That's something you're going to want to be aware of as well. So it's important to really get to know your clients and their lives in the United States from day one, as that's going to impact your work with them as well. So from the very first meeting throughout the life of the case, you're always going to want to constantly be building rapport with your client, keeping it up. These cases are intimate and oftentimes traumatic for clients to just discuss the details of their case. So it's important to really build and continue building trust with the client throughout the life of the case. And of course, this starts from your very first meeting. So number one, if you're working with a team, you want to make introductions and ensure that the client understands who everyone is, knows what the roles are, and understands confidentiality, that their information is protected. They know what you're going to do with their information. They can trust you with their story. It might be necessary to meet family, but generally during the first meeting, you're going to want to ask anyone who is not your client to step outside of the room so that you can take the time to get to know your client without the interference of anyone else. And as I've mentioned previously, getting to know their life in the United States. Where are they living? What are their concerns and priorities? It's also really key to develop a plan for communication from the very first meeting. So if you have a merits hearing coming up, planning meetings. Are they in person? How is the client getting to you? When are you going to meet about what part of the case? Even if you don't have a hearing coming up, it's still really important to develop a communication plan with the clients. As I said, housing can be unstable for some of our clients. Maybe they're living in shelters. Maybe they're just moving around a lot. Maybe their phone number changes from time to time. So staying in regular communication with your clients is really key to making sure you don't lose touch with them, and that causes issues later on in the case. As I mentioned previously, having a roadmap for how you're going to proceed with the case as well can be helpful for clients to orient themselves and to prepare themselves emotionally for any affidavit or testimony prep sessions, which can be really emotionally difficult. So it's important that your client knows ahead of time what's going on in the case and they don't feel lost in the organization of the case. Also, as I mentioned previously, many of our clients have lower levels of education or cannot read or write. So it's important that you take the time as well to explain your engagement letter in simple terms, obviously with the use of interpreter if necessary, so that the client understands the terms of your representation moving forward and address any questions that they might have at that time as well. Lastly, it's really important anytime that you're meeting with a client in person, take advantage of that opportunity to sign forms that you will need or that you think you will need, so that mailing or potential barriers to meeting with your client in person don't impact your ability to get filings out later on. So for example, we have your G28, your entry of appearance, or any FOIA forms if you're planning on submitting a request should be signed during that first meeting. So you have those on deck and ready to send out once the filing is prepped. So that's everything you should do. The number one please don't do during your first meeting with your client is not to talk about the client's claim unless they bring it up or they explicitly ask to do so. Again, the events of their claim are going to be traumatic. It's often tough for clients to talk about them, so it's important that they feel prepared to do so whenever you're going to ask them to relive those experiences. Most of you, if you take an asylum case, will be working with interpreters. Some of our clients speak English, but the vast majority do not. So this is an important skill to develop as well. The main thing to remember when working with an interpreter is that your interpreter is not a part of the conversation. They are just there to interpret. The conversation is still directly between you and the client. You are looking at and speaking to the client. They are looking at and speaking to you, and the interpreter is just interpreting exactly what you both are saying back and forth. Oftentimes, firms will have staff members who speak the client's language and they are able to assist, and that is wonderful. If you're not using a professional interpreter, it's important to set guidelines with the interpreter beforehand and make sure that they also understand the terms of interpretation and they understand that the conversation is directly between you and the client and that they should interpret everything directly as it is said. Short questions and avoiding compound questions are also useful with interpretation. Anything you can do to simplify the kinds of questions or the kinds of answers that your interpreter is going to have to translate to you is going to ensure that you have the most accurate interpretation possible. And then limiting the duration of your meetings, taking breaks for the sake of your interpreter and their ability to translate everything accurately is going to be important as well. We have a quick YouTube video. It's about 5 minutes. Let's see if we're able to pull it up. This is going to demonstrate how to and how not to effectively work with an interpreter. Let's see.
This video will show you how to work with an interpreter if you need help speaking with another person in a different language. What is an interpreter? An interpreter makes it possible for two people who do not speak the same language to understand one another. The interpreter does this by listening to the words you say and orally translating them exactly into words in another language. Now we will show you some examples of how to and how not to work with an interpreter.
Tell her I need to ask her some questions so I can understand her situation better.
Stop. This is all wrong. To avoid confusion, speak directly to the other person as if he or she could understand you. Do not use phrases like he said, she said, tell him, tell her. This is how the conversation should go.
I need to ask you a few questions so I can understand your situation better.
Quisiera hacerle unas preguntas para ver si puedo entender la situación mejor.
Sí, gracias.
Yes, thank you.
Much better. Remember to always speak directly to the other person. Now, let's look at another example of how to work with an interpreter.
When did you initially move into the apartment?
¿Cuándo comenzó a vivir en el apartamento?
Pues en el 2006, no recuerdo exactamente. Creo que era en el invierno, estaba nevando. Creo que el 3 de enero, no, el 5 de enero.
It was in 2006, January 5th.
Freeze. First of all, the interpreter should repeat the words you said exactly as you say them. The interpreter should not add, leave out, summarize, or change anything to what you said. Let's try that again.
When did you initially move into the apartment?
¿Cuándo comenzó a vivir en el apartamento?
Pues en el 2006, no recuerdo exactamente. Tuvo que haber sido en el invierno, estaba nevando. Quizás el 3 de enero, no, el 5 de enero.
Well, it was 2006. I don't remember exactly, but it was winter because it was snowing. I don't remember exactly. Maybe it was January 3rd. No, it was January 5th.
Much better. On to the next example of how to work with an interpreter.
Did you give a security deposit?
¿Y un depósito de garantía?
¿Qué es eso?
Ella se refiere al dinero que está reclamando, lo que le pagó al dueño al principio, por si acaso se dañaba algo en el apartamento.
Hold it. If you don't understand the question, it is the job of the person asking the question to explain the question to you. It is not the job of the interpreter to explain the question to you. Let's see what should have happened.
Did you give a security deposit?
¿Usted pagó un depósito de garantía?
¿Qué es eso?
What is that?
Besides the rent, did you give the landlord any money before you moved in?
Además del pago de alquiler mensual, ¿le dio al propietario algún dinero antes de comenzar a vivir en el apartamento?
Now we're getting it. Let's look at one more example of how to work with an interpreter.
Did you take pictures before you moved out?
¿Tomó fotos antes de mudarse?
No, en realidad no se me ocurrió. No pensé que tendría ningún problema.
Qué pena, sin fotos no tiene caso.
Stop, stop, stop. The interpreter should never give his or her opinion on what is being said, nor offer you advice about it. Let's try that again.
Did you take any pictures before you moved out?
¿Tomó fotos antes de mudarse?
No, en realidad no se me ocurrió.
No, I didn't really think about it.
Now that you've learned the right and wrong way to use an interpreter, here are a few rules to remember. Speak loudly and clearly enough so that the interpreter can hear you well. Speak at a normal pace or a little slower if you are usually a fast speaker. You may stop from time to time if you feel the interpreter needs to catch up with you. Wait for the interpreter to finish talking before speaking. Always remember, everything you say will be interpreted. If there is something you do not want the other person to know, do not say it to the interpreter. Do not expect the interpreter to soften your words or the other person's. The interpreter must keep everything you say confidential. This means that he or she may not share anything that you say with anyone else. For more information, contact Legal Services of New Jersey. Thanks for watching.
Okay, so hopefully that was informative. Now we're going to move into.
This video provides practical tips to help lawyers and their
Okay, I think we're back. Sorry about that. So now we are going to move into discussing these three elements of your filing, starting with the affidavit. So when you are drafting your affidavit, when you're preparing the whole case, credibility is the most important part of your client's asylum case. And the credibility determination can be based on the client's demeanor, their candor, the inherent plausibility of their situation, or consistency of their statements that they made at any time. So for instance, the credible fear interview could come into play here as well. However, the credibility determination that the adjudicator will make is mostly determined by the client's affidavit and their testimony. So this means that the affidavit is the most important piece of evidence in the entire case. So it's important that you are, we have some tips here for working with your clients in order to produce the best possible affidavit. As I mentioned before, all of our clients are trauma survivors, and working with trauma survivors does require a new set of skills. As Olivia mentioned, it's important to prepare before you meet with your clients so you know the facts of their case, they feel comfortable and confident sharing more with you, and you're prepared to work with a trauma survivor as well. So we have a few tips here. Tip number 1 is to meet frequently and for shorter periods of time rather than longer periods of time. That way you're limiting the amount of time your client has to spend in one go reliving their traumatic situations. And hopefully that will allow you to get more detail from them and craft a better affidavit. And it will possibly limit the amount of lapses in memory or other issues that can arise when the client becomes emotionally tired. You might try to provide empowerment to your client through giving them choices. Again, because this is a difficult process and they're having to relive this again, a choice as simple as, do you want to sit here or do you want to sit there? Do you want water? Do you want tea? Do you want to take a break? Maybe they'll say no. Can provide some empowerment and help them feel like they have some autonomy in the process. It's important not to expect your client to give you everything in a chronological order or with complete consistency. It's okay and it's normal for there to be inconsistencies on your first go. What's important is that you catch those, you put everything in chronological order, and you have it all ready to go by the time that the filing is set. Short questions, just like with interpreters, asking short questions, limiting the amount of information that the client has to convey at one time is helpful for getting the most amount of detail, and it's helpful for the clients as well. It can also be useful to explain why you need this information from your client and what you intend to do with it. So again, explaining confidentiality, ensuring that the client really understands why they have to answer all of these questions again. Likely they've already shared this story many times to many people, so it's important that they know what it's going to be used for, why it's necessary. And then our last tip is to bookend your interview. So rather than jumping straight in to the traumatic parts and interviewing them, lead up with some small talk, ask about how they're doing, and then end the same way so that hopefully the client can end feeling like they're in a stable place rather than emotionally unsettled. And with that, I'm going to pass it over to Jeff, who is going to talk more about the affidavit.
Okay, so as Lily just described, you're in this process, working with the client, asking questions, trying to understand the chronology, trying to understand the details of their story, trying to get it accurate. And, while you're doing that, you also have a goal in mind as to the end product and what you want it to look like. And so, what we're trying to do here is have a clear, compelling narrative explaining your client's reasons that they fear of returning to this country. And, there may be some other legal issues we need to address, like if we think there's a possibility of a statutory bar applying or something like that. But, the central thing is explaining that narrative, including whatever past harm there was and whatever reasons they fear future harm. And so, again, as Lily said, most important part of your filings, put the time into it, meet early, meet often. And while you're writing it, you want to, throughout, try your best to maintain the client's voice. Doesn't need to be verbatim transcription, but it should sound like them speaking, not like you. And that is part of how the judge will assess credibility. Does this sound like the person telling their story? You want events to go in chronological order. That's easier for the court to follow. That is, to the extent that on direct and cross-examination, you're visiting these events, it'll be easier if they're told chronologically in the affidavit. There are some instances where there might be slight breaks in chronological order for just logical storytelling reasons, but we encourage you to try your best to avoid doing that and keep chronological order as much as possible, because that will be the clearest thing at the end of the day. Curiosity, asking questions, and making sure you're covering all the questions. The who, what, when, where, how, all of, and the whys. Make sure that you are explaining everything that needs to be explained in the story. Obviously, make sure it hits on all of the asylum elements. You want to have facts in the affidavit that support every legal aspect of the claim. And you're going to always be thinking strategically about the length of the affidavit, the amount of detail, and consistency with other documents. So those FOIA requests Olivia mentioned, you're going to look what the client said in any previous encounters with the government and seeing if it corresponds to what they're saying now. And if not, you need to resolve those inconsistencies, try to figure out how to explain them. And in terms of level of detail, there's going to be a strategic consideration. The key thing is, at the end of the day, keeping things consistent. So if there's a detail that the client is not going to remember consistently, remember what Lily said about trauma and memory. It is very difficult to remember even normal events in a consistent way, let alone traumatic memories. And so you don't want to set your client up for failure by including too much detail. And so, just to give you some concrete examples of what mistakes might look like and what a better approach could be, let's just read through these. So first, I was persecuted because they belong to the group of Salvadoran females in relationships they are unable to leave. No one says that about themselves. And you're just implanting the legal standards straightly into the affidavit, not in their voice. Take that out. What you want are facts that establish that the client falls into that category, but obviously not the legal definition. Or how about when I told them I did not want to join their gang, they became more menacing. This triggered a melee with the whole group involved in kicking me. Some police came ostensibly to investigate, but the investigation was cursory and superficial and no arrests, and then a citation. Ari starts out not sounding like the voice most of us speak in retelling stories. And then when we get to ostensibly investigate and the way the investigation's being described, jumping ahead to the kind of legal points that you want to make rather than listening to how they're actually describing the situation. And in general, a citation like this one will immediately kind of signal this is not really in the client's voice because, that's not typically part of how someone tells the story again. Like I said before, too much detail can be dangerous. So on May 1st, 2010, 3 gang members stopped me after school and threatened me. Is the client going to remember the exact date the same way every time, or the number of gang members? They may, but I think there's a risk that you're setting them up to say something differently at the hearing, which could cause a credibility issue. So a more balanced approach might be something like, around May 2010, a group of gang members stopped me after school and threatened me. And I also want to highlight here, this is an event 13 years ago, right? So like the longer in the past something is, there's more reason why you might want to hedge a little bit. When we receive affidavit drafts and we're editing them, and this is a good time to highlight that if you're working on a case with us, we also have retainers with the clients, and we do ask to review all drafts, but before being submitted, ideally a little while before, so we have time to get you substantive comments. And when we're editing the asylum affidavits, it's very often we're running into issues with the voice straying away from the client's voice, or clearly have to make sure all of the asylum elements are met, and that's always going to be a focus. Needing more context and background. Basically, that takes the form of follow-up questions. Have you asked the client this? Have you asked this? Trying to flesh out that story so it makes sense to someone who is not an expert in the country that you're describing. And always consistency, consistency, consistency. We need to make every statement the client makes as consistent as possible with everything else. And if there are inconsistencies, if something was remembered wrong or stated wrong before, we have to explain that inconsistency, right? And that happens. It's not a reason to panic, especially in the border interviews that we mentioned before. A lot gets written down wrong, or it's an uncomfortable situation. Someone may state something imprecisely, and we just have to figure out what happened and explain it in those cases. In addition to the affidavit, we want corroborating evidence. This is the second most important part of the case, so you want to be working on it from the beginning. And it's important because under the Real ID Act, corroboration is going to be required unless the applicant does not have the evidence and cannot reasonably attain it. And so the applicant's testimony in itself can be enough to sustain the claim. Courts understand, and the laws contemplate the situation that many asylum seekers are fleeing their countries without anything. They do not have time to gather the ideal legal documentation when they're trying to get across the border into safety, right? So if other corroboration isn't there, you do not need it, but you need to explain why it's not reasonably obtainable. And you want to corroborate each element of the claim or show why the relevant evidence is not obtainable. We have some examples here of types of corroboratory evidence. Won't go through them in detail, but the takeaway is to think broadly about credible sources that will support your client's claim. And the other thing I wanted to mention here quickly is that another important thing is for any piece of corroboratory evidence, we want to understand the provenance and make sure that there are no concerns about its accuracy or credibility, right? Obviously, if something raises those concerns, we would not want to submit in that case. So returning to Patricia's case, actually, I think I apologize, I said we would return to it in the section, but I think in the interest of time, because we're running a little bit over, we won't go into this, but you can kind of look at this example later and think about what types of corroboration could exist. Again, the main takeaways here are to work with your client on identifying corroboration. They likely know much more than you do about what could be attainable. Like I said a moment ago, the chain of custody is important. We want to establish that's a credible document and be satisfied with that ourselves before submitting it. There aren't strongly articulated evidentiary standards in the immigration court. The federal rules of evidence do not apply. Generally, if something's probative and fundamentally fair, it can come in. All of the arguments you'd make about evidence go to, typically in terms of admissibility, all those arguments will go to weight in most cases. So you can be creative about what corroboration you submit. It does not have to be something that would be admissible in an Article 3 federal court. If you have any foreign documents, those need to be translated into English, and you need a certified translation. Again, we're always thinking about these elements together: the affidavit, the corroborating evidence, legal argument. And for legal argument, in the brief, you want to keep it short. There's a 25-page limit. You can technically motion for more pages, but IJs do not want you to. If you can at all avoid it, that would only be in exceptionally complicated cases. Make sure you follow the elements, keep them separate. If you're briefing in the Seventh Circuit, follow the local case law. Make sure that you get things for us to review, and make sure you preserve all arguments and claims to relief. Even if something's not your main argument, we want to make sure we have adequately preserved it for appeal. While the case is pending, make sure you're in contact with the client and do what you can to gather evidence and and in many cases, it will be personally helpful to the client to connect with therapist or a therapist, in which case we can help with making recommendations. Also, mental health and forensic medical screenings can be very crucial parts of the evidentiary record. And so that is something else that we can help with, recommending providers that they can go to for those types of evaluations. Once the applicant is eligible for work authorization, you want to file. That's the 150 days that Olivia mentioned before. And so once the application is filed, and there will be either like a stamp from the court if it's filed in court, or if it was an affirmative case, there's a receipt notice from USCIS. But from that date when it's officially filed, a clock starts running, and the court will maintain this clock for these cases. So you can, on ECAS, see how many days are on the clock, or calling the automated system, you should be able to verify how many days are currently on the asylum clock. And once that clock gets up to 150 days, that's when they're eligible to file for the EAD. You should target filing immediately when the clock reaches that number. And the reason why there's like sort of a formal counter and why we refer to it as a clock is that certain actions by an applicant can stop the clock. So if you do something that actively delays your case, that will stop the asylum clock. And if it's an applicant cause delay, then that means you won't be accruing days toward being able to file that EAD application until the clock is subsequently restarted. But by generally that'll happen by another hearing occurring in the case. But there's some nuances there. But yeah. So main thing though, as Olivia said before, is make sure that you're calendaring this. If your client already has an EAD, make sure you calendar renewals. You want to renew 180 days before the EAD expires. You also want to, as part of keeping in contact with the client, be aware of major life developments. We also ask that clients report these to their attorneys, things like marriages, birth of a child, being a victim of a crime. These are situations that could open up other forms of immigration relief. They don't always, or in some cases, they could affect the strength of the asylum claim. And so we want to be sure of that we're updated on major life events. And I'll say, in addition to victim of a crime, if the client is ever arrested or accused of a crime, that is something that we absolutely want to know about and think about how that factors into the case. They should not be filing any other applications for immigration benefits without consulting you first. Again, this is partly the consistency issue that we mentioned before. We want to make sure everything we say is consistent. And if you become aware of anything that you think would make your client eligible for another form of immigration relief, so something they tell you falls into one of those categories we mentioned before, or you think for some reason they're eligible for something else, let us know and consult with us about that. And with this, I will pass it back to Olivia to talk about presenting the case.
Thank you so much, Jeff. All right, you're familiar with asylum law. You have your evidence. You've been working with your client. Let's talk about what happens when we're getting ready for an immigration asylum merits hearing. First of all, you are going to need to file all of those documents you prepared. That asylum application should already be on file. Your appearance with the court, that Form E-28, should already be on file. And then, as we talked about, you're going to have a filing deadline, typically 15 days before the hearing. In some situations, it may be a little bit different number, 14 days, 30 days, check with your point of contact. At that filing deadline, you are going to need to submit the brief, the client affidavit or declaration, a notice of amendments to the I-589 application. As you've heard us talk about over the course of this presentation, years can go by between the initial filing and the day of the merits hearing. So there will be new information, new addresses, new employment history, maybe a social security number the client didn't have at the time of the initial application, and we want to provide all of that information to the court. You're also going to file an annotated index that draws the adjudicator's attention to the parts of our country conditions evidence that we really want their focus on. And then finally, all of that supporting documentation, identity documents, expert affidavits, all of those other documents that Jeff and Lily just talked about. Remember, anytime you file something with the court, you must serve a copy on the government. If you are filing by paper, you can serve those documents on the government also on paper. You can mail or send by courier service, or you can register for ICE's e-service portal and you can send an electronic copy. If you are filing through ECAS, the government has access to that, and you do not have to provide separate service, but you still have to provide a certificate of service that says basically this document was filed through ECAS, no separate service is necessary. If you don't include that certificate of service, ECAS will reject your filing. So you do have to include a certificate of its service, take that step no matter how you're filing, but it's a little bit simpler for ECAS cases. For your corroborating evidence, you're going to have an index that looks like this. Usually the affidavit is the first thing. That is a comprehensive view of your client's, I don't like to say their whole story. It's not their whole story, right? But it is a digestible, readable description of the legally relevant parts of their story. And then you're going to have all of those other documents we talked about. And as you can see, the country conditions are annotated to really emphasize the facts that we want highlighted in the record. There are particular requirements for formatting a filing. The immigration court has a practice manual. It's available online. That is a great first step if you are prepping a filing. Ditto, our asylum manual has some tips in it, but a few points that I will highlight right now. One, as I've said on every single slide on this section, please annotate the index in order to highlight important country condition reports. Secondly, two-hole punch the filing at the top and make sure that filing is printed single-sided. I understand why we print some things double-sided. It is better for the environment. If you give the court a single-sided filing, that judge will read only the odd pages of your filing, which is not what anyone wants. Single-sided, please, when filing with the court. For paper filings, alphabetical tabs on the right side, make sure it's consecutively paginated. For electronic filings, still paginate, and you can use digital exhibit stickers or placeholders, right, rather than physical tabs. Paper records, we talked about this. They can be filed at the court window. Whenever we are filing on paper, we want proof of filing. The court moved recently. Things get messy. Things can get lost. It has happened. We always want proof of what we submitted. So we really encourage you to take that filing, plus your own copy, to the window, get your copy date stamped, bring it back with you. If for some reason you can't make it in person, you can mail in your original filing and the extra copy with a prepaid return envelope to get that date stamp copy sent back to you. ECAS, as always, much simpler. You upload online, be sure to include that certificate of service, even though there is no separate service, and you will be able to see in your portal once it's been accepted, and you will have an access, digital access to the full record of proceedings. All right. Getting ready for the merits hearing. You are going to need to prep your client. We generally recommend 3 practice sessions. This is assuming that at each practice session, you can get through a replication of an entire hearing. For some clients with schedule or other needs, you might have to do fewer, or you might have to do more practices that are shorter, right? But the ideal we're going for is an initial practice to get your client situated, to give them a sense of what this hearing is going to look like. Then maybe a tougher session, a session where you really push them to be responding in the ways that you're looking for, to practice really listening for the question, answering the question that was asked. And you go through that cross-examination prep as well. And then third, prior to the hearing, we want to be sure there's a confidence building session so that client can walk into that hearing knowing that they know as much as possible what to expect. They know what questions you're going to ask. They know what kind of answers you're looking for. Of course, we can't know exactly what's going to happen on cross, but we can usually predict or guess, and we can give them tools to feel prepared for that as well. At that first meeting, or even before, you're going to want to go over the process with the client, right? You're going to want to explain that you're going to go in this courtroom, they're going to have to take an oath, they're going to have to swear to tell the truth, right? And then you will question them on direct, there will be cross-examination, there will be redirect, and then you'll provide a closing statement. We also want to prep them that the judge might be jumping in at various points to ask questions as well. It's also important to talk about your theory of the case with the client. You don't need to get into like the legal weeds and the case law, but we want to make sure our clients understand what asylum is and what we are explaining in the courtroom. As I alluded to earlier when we were talking about the affidavit, right? Our clients have many, many, many experiences, all of which are very important to them, and only some of which are legally relevant to the case. So we want to help our client understand going into the hearing what we're going to be focusing on and why. I often work with clients to come up with 3 to 5 things that if the client knows they have talked about those things in the hearing, then they know they have said the most important pieces of their case. And that can help prevent a client from getting anxious and feeling like I have to talk about everything that has ever happened to me because this is my one chance to share it, right? When a client is comfortable with the theory of the case, it's going to be a lot easier for them to stick with those questions that you've prepared and understand why the hearing is unfolding the way it is. Finally, we want to manage expectations, and you want to empower your client to say if they don't remember something, they don't know something, or they don't understand something. We don't ever want a client to be in a position of like making up an answer or fudging something because they're just overwhelmed and the judge has asked about this date 3 times in a row and they feel like they just have to say a date. That can be a big credibility concern right there. So we want clients to feel really comfortable saying, I'm sorry, I don't understand, to flag if they're having an issue with the interpreter, and to just stick to it if they don't remember something, to let the court know that they don't remember. You can help them find guideposts, right? It was winter, it was near my son's birthday, but if they don't know, then it's better to say they don't know. Not only should you prepare your client, you should prepare yourself. Here are some things that you can do to get ready for a hearing. 1, we keep lists as best we can on contact information for opposing counsel. Obviously, staffing changes, things shift, but we do our best to be able to provide not just contact information, but any intel we have on those other attorneys or on the judge. So definitely reach out to us. We can let you know this judge really asks a lot of questions, or this judge frequently grants on this particular social group, but is really skeptical of and like does not like to grant cases with this other particular social group, right? We can kind of help you prepare for what you might get that day of the hearing. We do encourage reaching out to opposing counsel, see if they'll stipulate to anything, see if they're willing to share their position on the case. I will be honest, we don't always get responses, but it looks a lot better to the judge to show that we have made that attempt, we've made that effort, and sometimes we do get really helpful information. Sometimes opposing counsel will say, hey, I read your client's affidavit. They do not need to testify about this past harm. It was credible. I can see that's really traumatic. Let's just focus on this specific issue. Then, of course, there is the procedural manual. As always, that's your reference. Take a look at it again before the hearing for another run through and kind of step-by-step information about what to expect. After the hearing, a couple things can happen. Hopefully, your client is granted asylum. That is awesome. Tell us right away. There is a limited window for clients to access benefits, and we want to make sure that we get them in touch with services as quickly as possible. We will ask for your assistance in making sure your client gets an I-94, which is the document that gets sent actually from USCIS, proving that they have asylum status. They are also eligible for an asylum-based work permit, although they can work even without it as an asylee. And then we have clinics that can help asylees apply for derivative family members who may not have been included in their application. If we don't get asylum, reserve appeal. Reserve appeal and come back and talk to us, and we can talk about what an appeal might look like for that case. Once the case is done, we have finished, it is a wrap. Here are some things you can do. You can celebrate. Celebrate with your client. People often go out to lunch with a client or get a meal or something post hearing. Celebrate with your client, celebrate with your community, with your families. You can take another case. We have many. I want to say a big thanks to Josh, who's told us right earlier today that after his case, he's already back and working on another NIJC case. You can also recruit your colleagues. We have lots of cases. And if you are maybe worked in a team of 3, you each grab a colleague and offer to mentor them or co-counsel with them. That's a lot more people to whom we're providing representation. You can also donate. You'll see it on the next slide. We are a nonprofit. We depend on contributions to continue this work, and financial contributions can be another way to celebrate and promote the work. And then you can advocate for justice for immigrants. If you are at this hearing, I imagine you have a network, you have platforms, right? We encourage you to take your experiences working with asylum seekers and share them, elevate them with your networks, with your communities to bring more people into this work and into these initiatives.
I can cover this slide, Olivia, as we're jumping in, but do you want to give our last CLE code as we're wrapping up?
I was gonna ask which of us should do it. Our last CLE code is appreciate. We appreciate our generous pro bono network. We appreciate Better Price for hosting us today, Josh for speaking and sharing his experiences, and all of you for sharing your time and energy with us. Thank you so much.
Holy moly, we did it. That was 2.5 hours of a lot of information. So we talked about what is asylum. We talked about how to build your case. We talked about how to interact with NIJC clients and soon to be your clients. And we talked about NIJC's pro bono program in general, right? Thank you for being here today. Those online, thanks for joining us. Those in person, love to see you in person, so thank you. I know that lunch is waiting and we're almost at the hour. There are still a couple questions that some of our folks have, and we'd like to hear more questions in the audience. I will say though, none of us live under rocks. There's a lot going on in the asylum world right now. There's a lot going on in our immigration world right now. And there's a lot of people arriving to the streets of Chicago and other cities across the country. More and more buses are coming and it is getting colder. We are getting a lot of inquiries. What can we do? What can we do? Honestly, take an asylum case, because like Lily said, we have a one-to-one model. When you take a case, we can then pivot and respond and try to work with the city, the state, and other actors to get the next response building, right? I understand that there's a mix of folks in the room. If you are not from a medium or large size law firm or corporate partner or corporation in-house team, and you don't have those resources behind you, so you might be a small firm attorney, you might be a solo practitioner or nonprofit, reach out to us. We do have a couple of options like Lily talked about, and there are some specific cases that might work for solo or small firm practitioners, right? But we do understand these take time. I also wanted to mention that this is the second of 3 events that we have this fall. We are excited to celebrate Better Prices wins and all of the wins in our community. I know with our Afghan lawsuit, we had 5-6 Afghans approved for asylum just this week, which is really, really, really exciting because now they can finally be reunited with their family members that were left behind during that tragic evacuation. So we are moving things forward. We'd love to celebrate with you all on November 2nd, which is our pro bono celebration. We hope you can join us, generously hosted at DLA Piper. It's not hybrid. Y'all got to show up in person and give us high fives and eat cookies. So we'd love to see you there on November 2nd. Yeah, we'll be sending the links around. And then finally, if it doesn't have to be an or question, it can be an and also, right? But we are a nonprofit, like Olivia started saying. And so the work that we're doing, especially those with recent arrivals and being able to pivot to be agile, we don't yet have funding for that. Crises continue to develop. We need to respond. And so your funding can also help us and keep us agile in that way. I keep using that word because it is the word of the season, it seems. But your funding does support, and here are some ways that your funding can support us if you're able to provide in that way as well. I know that there was one question in the chat. We have just a couple minutes for other questions, but Olivia or Jeff, one question in the chat was just kind of to review, when do you submit the affidavit? Can you kind of review when are documents submitted and how does that prep? Jeff, you want to take it?
Sure. So the affidavit, along with the corroborating evidence and the legal brief, will be submitted together, and that is the filing date that Olivia mentioned before. It is generally 15 calendar days before the merits hearing. Some judges may set a separate timeline. They will have to do so explicitly if that's the case. Typically 15 days.
Awesome. Before we get to other questions, I'll just reiterate, because I know our team answers lots of these questions that are written in our manual. So all of these details are in our manual. Pro bono attorneys say it's like the Bible or the Quran or whatever religious book, or the dictionary for your process, right? So use that manual to your advantage and reach out to our staff when you want to talk about other questions. Finally, one other logistics thing before we go into more questions. CLEs. I know y'all want CLEs because you've been sitting here for a minute. So you should have, for those in person, you should have signed in with the QR attendance code. Those online, we have your WebEx attendance record. Better Price sent around a affirmation of CLE, which you need to send back to them within 1 week. Within 1 week. Even if you are not an attorney, but you're going for DOJ accreditation and you need a certificate of participation, please also fill out that affirmation. Any questions about CLE can be directed to myself or to the Better Price contact that sent you that affirmation sheet. What other questions do we have? Do we want to talk about biometrics again? Yeah, question right here. 14? No. We can double check that for you. I think it is 14 if they haven't changed things. They tend to change things sometimes and not tell us, but I do believe it's 14. Okay. Yeah, in the back.
So how will I know if I need to assert the biometrics data? Like, I just know it came into the file, the biometrics was done. How do I verify whether it's still current?
So
Maybe the questions for folks on WebEx, I'm seeing a lot in the chat, and I also can vouch, I cannot hear the questions.
Okay. So the question is, how do we verify whether biometrics are current? And that is the email address that Olivia mentioned before. There's a dedicated account at the Office of the Principal Legal Advisor, that's ICE Counsel, that responds to questions about biometrics requests and requests to update. And you can email them to ask whether the biometrics are up to date.
So should I email them within 3 months of my marriage hearing?
Right. So the question is when to email them. And generally, you'd want to do at least several months before the merits hearing. I don't remember exactly how long biometrics are good for. Olivia, jump in if you know. I want to say 2 years, but I'm not certain. It's at least several months.
Say 2 years, but I'm also not 100%. I typically email when I first get a case just to check if they have them, and then I email again like.
Yeah. Yeah. Yeah, absolutely. Like if there's any doubt that the biometrics have been done, you want to email right away just to confirm that the prints are there, even if you have to refresh again later. You know, you can email now, check to see if they have the prints, and then refresh when you have a merit state set.
Awesome. That brings us to time. I forgot to introduce myself, though. I'm Ellen Miller. Use she, her pronouns. I'm pro bono manager at this fabulous organization with these fabulous partners. We look forward to being in touch with you. Please know that every case, every client does make a difference. So if you can help, please do. We look forward to working with you and to talking with you. And thanks again for showing up today.